Welcome, everyone. I'm so pleased you're able to join us today for this webinar, which I think will be very, very interesting. It's my privilege to introduce our speakers to you, but before that, a few housekeeping things. At the end of the presentation, we will have questions and answers, and I want you to please use the Q&A function and not the chat function. And then if you see a question you like, please vote on that question, and that way we can make sure the questions that most people want to have answered will be answered. Secondly, there will be a slide deck that we use to show this presentation that will be sent to all the participants probably tomorrow or at least by Monday, because I want to send that to everyone participating. At the same time, I send you the link because this video is also being recorded and will be available on ULaw's YouTube page. So thank you again for joining us. Our participants for this panel are Mickell, Jimenez, and Judd. Mickell is at Holland and Hart, where she advises business owners and management on the full spectrum of employment issues that can impact an enterprise. She provides upfront guidance to help position businesses to effectively mitigate risk. In addition to her extensive bio, I asked each of them to tell me something that no one knows about them. Mickell is a 25+ year yogi, and she goes to yoga retreats to recharge, and she's participated in yoga retreats all around the world and hopefully hopes to make it to Thailand in March of 2021, depending on the state of the world. Judd is at Lucid, where she is honored to serve as the Vice President of People and Culture, and she's been in that position since 2017. She believes in empowering people, understanding that it's important to provide employees with the right tools so they can deliver excellent work. She has 10 years of experience as a management side employment law attorney, focused on preventative advice and counsel, workplace investigations, and employment law training. She was named the Young Alumna of the Year in 2016, and she also holds a bachelor's in business administration from BYU, and she is, of course, one of the U's honored alumnus. So thank you very much to both of you for participating in this. And now I want to turn this over to Mickell, who will begin the presentation.
Good afternoon. Thanks, Lori. That was a very kind introduction. And thanks everyone for joining today for this webinar. Kat and I are really excited to have what we hope will be a semi-interactive discussion given the circumstances of our gathering. I am going to share my screen now and hopefully do that successfully. All right. So we're going to start today. Kat, let me know if my screen sharing needs to.
You look good. Yep.
Okay. Thank you. We are talking today about SCOTUS's ruling, the Bostock decision. SCOTUS rules Title VII prohibits gay and transgender discrimination. What you need to know and key takeaways for employers. As Lori indicated, Kat and I will be co-presenting today, which we have been excited to partner on this presentation. Legal disclaimer, of course. This presentation is designed to provide general information on pertinent legal topics. It is for educational purposes only. The statements made and the information included do not constitute legal advice, nor financial advice, nor do they necessarily reflect the views of Holland and Hart or Lucid, other than the two participants speaking today on an individual basis. The information is not intended to create an attorney-client privilege with Holland and Hart and you, or a relationship between you and Lucid Software. Changes in the law or changes in the facts of a particular case, of course, could yield a different outcome. So if you have specific questions as to the application of the law to your activities, please seek the advice of your counsel. So what is the big picture? On June 15th of this year, our U.S. Supreme Court issued a long-awaited decision in Bostock v. Clayton County, Georgia. The court there held simply that an employer that discharges an individual merely for being gay or transgender violates Title VII of the Civil Rights Act of 1964. In this webinar, Kat and I will review and discuss the 3 cases that SCOTUS granted certiorari on that became the Bostock decision, what this important ruling means for employers, and some key legal and practical takeaways. So we're going to start with our first interactive poll. The question is, have you or do you know someone who has experienced LGBTQ plus discrimination in the workforce? If you'll take a moment to vote on the poll, we'll give a few minutes for the data to roll in, and then we will post the results. Actually, not a few minutes, maybe half a minute. Okay, let's see what our results yield. Looks like 36% of you said yes, you know someone who has experienced this type of discrimination, and 64% of you said no. So that is good to know. If it's not happening, means we have work to do if people just aren't speaking up. So let's talk about the cases. Thank you. Pure procedural background. This was not the result, the Supreme Court's decision was not the result of just one case. It was actually the consolidation of 3 different cases. The first being the titled decision, Bostock v. Clayton County, which started in the Northern District of Georgia back in 2017 and made its way up through the 11th Circuit. The second case is Zarda v. Altitude Express, Inc., which came out of the 2nd Circuit in 2018. And the final case is Equal Employment Opportunity Commission v. RG and GR Harris Funeral Homes, Inc. And that case came out of the 6th Circuit in 2018. So these 3 cases, all the Supreme Court decided to grant cert on all of them and then consolidated them for purposes of this decision. Second poll. Who authored the Bostock decision? This will be a multiple choice question. Was it A, Justice Ruth Bader Ginsburg, B, Justice Clarence Thomas, C, Justice Neil Gorsuch, or D, Judge Judy? We'll take another few seconds for everyone to make their pick and vote on the poll. Okay, let's see what the results yield. We have 25% picking Justice Ruth Bader Ginsburg, or as she is better known, RBG. 21% Justice Clarence Thomas, 54% Justice Neil Gorsuch, and nobody chose Judge Judy. The correct answer is C, Justice Neil Gorsuch. Next question. Why is the author, Justice Neil Gorsuch, of the majority opinion significant? A, because the author is a Trump appointee, B, because the author is not a lawyer, or C, because the author is a baby boomer. Take a moment to make your pick and vote. Okay, let's see what the results yield on that one. 83% because he is a Trump appointee and 17% because the author is a baby boomer. The correct answer is A, because he is a Trump appointee, though his baby boomer status may have had some impact on his opinion. What is important here, there are many things important about this case, but in terms of Neil Gorsuch, Justice Neil Gorsuch authoring the opinion, is that he is considered a textualist. And his majority opinion is an academic textual analysis. So he did stay true to that analysis. The Gorsuch's opinion in Bostock scrambles our understanding about what it means to be a conservative versus a liberal justice, because despite his conservative views and his conservative politics, Justice Gorsuch followed the broad language of the civil rights law while at the same time honoring his textualist approach. His opinion, along with the support of some of the other Chief Justices, shows that you can follow the clear text of the law even when it leads to a decision that parts with your political views. So interesting here, we had a Supreme Court split. We have a 9-justice panel on our US Supreme Court, and as you can see here, we had 6 justices that voted for with the majority with Justice Gorsuch. That included Justices Ruth Bader Ginsburg, Kagan, Breyer, Sotomayor, and Chief Justice Roberts, and 3 dissenters, Justice Alito, Thomas, and Kavanaugh. Justice Kavanaugh notably wrote a separate dissenting opinion. So why is this split important? Interestingly, the political implications have caused a lot of shockwaves throughout the legal community. A conservative stacked court decided a landmark victory for LGBTQ equality. This is particularly important because Justice Gorsuch was a Trump appointee. In fact, he was the first appointee that Trump made and the first nominee after he took office, the second being Justice Kavanaugh. Chief Justice Roberts is also a conservative appointee being appointed by President George W. Bush, and he joined the majority opinion as well. That was also significant because in the past he had authored dissenting opinions in the landmark case that legalized gay marriage. And now I'm going to turn it over to Kat.
Thanks, Mickell. So I want to go over some of the key holdings. You're welcome to screenshot some of these. This is language taken right out of the opinion, and that'll be a basis for later on. We're going to go through some hypotheticals together. So some of the key holdings that we have here is that Title VII makes it unlawful for an employer to fail or to refuse to hire or to discharge any individual or otherwise to discriminate against any individual because of such individuals' race, color, religion, sex, or national origin. So we know that's Title VII. And then going into the opinion, they talk about how an employer who fires an individual for being homosexual or an employer who files an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undistinguishable role in the decision, exactly what Title VII forbids. And continuing on from that, there's a but-for causation standard. Employers can't escape liability by arguing that there were other factors considered as well that were not based on sex. They say it makes no difference if other factors besides the plaintiff's sex contributed to the decision, or that the employer treated women as a group the same as compared to men in the group. A statutory violation occurs if an employer intentionally relies in part or an individual's employee's sex when deciding to discharge that employee. Because discrimination on the basis of homosexuality or transgender status requires an employer to intentionally treat individual employees differently because of their sex, there's that because of, an employer who intentionally penalizes an employee for being homosexual or transgender also violates Title VII. There's no escaping the role intent plays. Just as sex is necessarily a but-for cause when an employer discriminates against homosexual or transgender employees, an employer who discriminates on these grounds inescapably intends to rely on sex in its decision-making. So the final key holding that I wanted to point out is an employer who discriminates against homosexual or transgender employees necessarily and intentionally applies sex-based rules. I think this is really helpful, especially if you have clients who are very used to, the protected classes being, age, race, religion, gender, sex, that they're like, wait, but that's not on the list. This is a good quote you can give them and say, no, because homosexual or transgender employees necessarily intentionally, it applies sex-based rules. Like we're looking at sex. So that's a good thing to hold on to if you've got clients that are having a hard time coming around on this. I turn it back over to Mickell. So those are the holdings that we did have, but there were some other arguments that were rejected by the majority. And that way, in case you have some sort of cases that come up, that you know the winning arguments as well as arguments that were rejected.
All right, can you hear me now? All right, we're going to look at the 4 major arguments that were rejected that employers raised in these 3 decisions. As some of you may know, or many of you may know, the Bostock decision is approximately 170 pages long. And so we are truncating into the kind of 4 major broad arguments that employers made that were rejected. So the first one, the first argument that employers made was that Congress would have specifically included it if they wanted these 2 classes covered, if they wanted to cover transgender and homosexuality, and being gay or homosexual in the definition of sex. Justice Gorsuch rejected that idea that because Congress did not address sexual orientation or transgender status specifically in Title VII, that Title VII does not protect LGBTQ plus employees. Discrimination against LGBTQ plus employees, Justice Gorsuch made clear, necessarily entails discrimination based on sex. The first cannot happen without the second. Justice Gorsuch explained there is no such thing as a canon of donut holes. I kind of liked that imagery, in which Congress's failure to speak directly to a specific case that falls within a more general statutory rule creates a tacit exception. Rather, Justice Gorsuch explained, if Congress establishes a broad rule without any exceptions, then the court is going to apply that broad rule. The second of the employer arguments made that the court rejected was that Congress's failure to pass amendments in the past was evidence that these classes were not intended to be covered. The majority also rejected this idea because they said we cannot know what was in the mind of Congress. They could have not passed because they thought it was already covered. The fact is there is a broad rule passed by Congress without specific exceptions. And if that occurs, then we, the court, apply it broadly. And as we all know, even beyond that, it would be difficult to hang your hat on the fact that Congress did not pass a particular amendment. Amendments often fail at the 11th hour because they lack funding, because somebody's pet amendment to fund something else that's even unrelated to the major package doesn't get put in. There are trading of political favors. And so I do think that in sticking to the textualist view and not wanting to go beyond that and try and divine what Congress had in mind when it did or did not pass an amendment would be a little bit dangerous for a court. The third argument that was put forth by the employers that the Supreme Court rejected was the argument that the plain meaning could not have included these classes because in 1964, these classes could not have been anticipated. So Justice Gorsuch pointed out that the employers suggest not that the statutory language bears some other meaning, but that because few in 1964 expected today's result, we should not dare to admit that it follows ineluctably, I always say that wrong, from the statutory text. That argument asked the court to merely point out the question, refer the subject back to Congress, and decline to enforce the plain terms of the law in the meantime. But even if it were true that no one in 1964 would have expected this result, Justice Gorsuch pointed out that there in fact were lawsuits filed by LGBT employees in the late 60s and 1970s, which countered this idea because at least some people foresaw this potential application. Justice Gorsuch also stressed that this is exactly the sort of reasoning this court has long rejected. Indeed, he observed many, maybe most applications of Title VII sex provision were unanticipated when Congress passed the law in 1964. Fourth and finally, the employers argument that was rejected by the court was that the decision is to hide an elephant in a mouse hole. This is similar to the argument that the plain meaning could not have included these classes in 1964. But Justice Gorsuch, again, he pushed back on this argument. It invoked a popular principle of statutory interpretation, being the idea that Congress did not intend to hide an elephant in a mouse hole. Justice Gorsuch explained that the principle is intended to recognize that when Congress wants to make important changes to a regulatory scheme, it does so clearly rather than using vague terms or ancillary provisions. And Justice Gorsuch agreed that the ruling was an elephant. But Title VII's ban on sex discrimination in employment, he emphasized, is no mouse hole, but instead a major piece of federal civil rights legislation written in starkly broad terms. The elephant has never been hidden in a mouse hole, Justice Gorsuch concluded. It has been standing before us all along. So these were the four main arguments that were put forth by the employers regarding their particular cases. So next poll, pre-Bostock, gender identity and transgender status were covered by how many states' anti-discrimination statutes? We'll take a few seconds for you to vote. Okay, let's take a look at the results. 57% of you said 5 states, 35% of you said 32 states, 4% of you said 48 states, and 4% said no states. The answer is B. In total, 32 states, including Washington, D.C., had implemented at least some kind of workplace non-discrimination law or administrative policy that protects gay and transgender workers from discrimination. Interestingly, and of note, since we're here in Utah, or many of us are here in Utah, Utah had passed an amendment to the Utah Anti-Discrimination Act in 2015 that expanded coverage under its local anti-discrimination law to cover sexual orientation and transgender identity. So let's break that down just a little bit. Of those 32, 16 states plus Washington, D.C. passed laws that prohibited discrimination on the basis of sexual orientation and gender identity. 5 additional states had passed laws or enacted policies that prohibited discrimination on the basis of sexual orientation, but not gender identity. And some states had extended non-discrimination protection to their state's public employees, but it did not apply in the private sector.
All right, so let's go over some practical application here. Now that we've gone through the key holdings, the arguments that were rejected. So let's go through this. This is a lot of words, I know, but we're all doing this virtual, and so it's not as bad having it like a million words on the screen here. So here we go, and I'm going to be asking you at the end of this. So be thinking in your mind, is this discrimination or not under Title VII? So Gary is a gay male who has worked for city and county for 10 years as the Child Welfare Services Coordinator assigned to the juvenile court. During his 10 years with CNC, Gary has received good performance evaluations, and the program he manages has received local and national awards of excellence. 6 months ago, Gary became involved in a gay recreational softball league. Gary actively promoted the CNC juvenile court program as a worthy volunteer opportunity. Gary says that in the past few months, his participation in the gay softball league and his sexual orientation and identity were openly criticized by one or more persons with significant influence on CNC decision-making. For example, in May 2020, during a meeting with Friends of CNC Advisory Board, at which Gary's supervisor was present, Gary alleges that at least one individual made disparaging comments about his sexual orientation and identity and participation in the league, the gay softball league. In or around April 2020, CNC advised Gary it would be conducting an internal audit on the program funds that were managed by Gary. Okay. Gary contends that he engaged in no improper conduct and that his audit was pretext for discrimination. On June 3rd, 2020, CNC terminated Gary allegedly for conduct unbecoming. That was the reason they gave. Conduct unbecoming one of its employees. Gary alleges that this reason was pretext for discrimination based on his sexual orientation. So with those facts, let's do a poll. Is this discrimination, yes or no? Is the reason that he got fired discriminatory? All right, let's close the poll and see the results. Okay, so 84% say yes and 16% say no. So that's a very interesting mix. So until Bostock, we didn't know. So the 11th Circuit, a Court of Appeals, held that Title VII does not prohibit employers from firing employees for being gay. All right. But then the Supreme Court holding that we're talking about today reversed that judgment of the 11th Circuit, and the case has now been remanded. Let's do another practical application. Mickell. Mickell, you're on mute.
Yes. Multitasking here, moving the slides and unmuting. Okay. Lisa is a transgender woman working as a funeral director at Golden Fields Funeral Home. For most of her employment, Lisa lived and presented as a man. Golden Fields has a sex-specific workplace attire policy. Lisa informed her employer that she was taking vacation and upon return to the office would begin presenting as a woman and dressing consistent with the women's dress code for work. Golden Fields terminated Lisa. So we are going to open our next poll, and it is this. Is this unlawful sex discrimination? And here are your choices. A, no, because the sex-specific dress code equally burdens male and female employees. B, no, requiring the funeral home to employ Lisa while she dresses and represents herself as a woman constitutes an unjustified substantial burden on the owner of the funeral home's closely held religious beliefs in violation of the Religious Freedoms Restoration Act. Looks like the end of that was cut off. C, yes, but for her transgender status, Lisa would not have been fired. Or D, yes, and enforcing Title VII is the least restrictive means to eradicate workplace discrimination, even if the RFRA, the Religious Freedom Restoration Act, is implicated. So take a minute to look at those four options and vote on the poll. Okay, let's go ahead and close the poll and show the results. Okay, 6% of you said no. The sex-specific dress code equally burdens male and female employees. None of you said no, requiring the funeral home to employ Lisa while she dresses and represents herself as a woman constitutes an unjustified substantial burden on the owner in violation of RFRA. 71% of you said yes, but for her transgender status, Lisa would not have been fired. And 24% of you said yes, and enforcing Title VII is the least restrictive means to eradicate workplace discrimination, even if RFRA is implicated. And the answer to this poll could be C or D. And interestingly, the first two options, A and B, were the arguments that the employer had set forth in the Stevens matter in opposition to the claims that the EEOC brought. Whoops, sorry. Not sure. Okay, so this hypothetical or practical application came from one of the underlying Bostock decisions. This was the Sixth Circuit case, EEOC v. RG and GR Funeral Homes. And again, the Sixth Circuit Court of Appeals held that the funeral home engaged in unlawful discrimination against the plaintiff on the basis of her sex. But for her transgender status, they would not have. Now let's do one more practical application with Kat.
Okay, thanks. Here we go. So Gary is a gay man working for High in the Sky skydiving as an instructor. As part of his job, Gary participated in tandem skydives with clients to which he had to be closely strapped. Gary would often disclose his sexual orientation to his female clients to address any concern they might have about being strapped to a male. Yesterday, a female client accused Gary of inappropriately touching her and disclosing his sexual orientation to excuse his actions. High in the Sky has come to you for advice on whether to terminate Gary for misconduct. All right, so think about gender stereotyping. Is this gender stereotyping? And with that, let's talk about, is this discrimination in violation of Title VII? So let's do a poll on that. So is it discrimination in violation of Title VII? One option is yes, it's a violation of Title VII because it discriminates against an individual because of sex, or no, even if distasteful sexual orientation discrimination on the basis of being gay or lesbian constitutes nonconformity with gender stereotype, which is not cognizable under Title VII. Okay, let's see the results. Okay, very good. It says most 64% said yes. So about 2/3 said yes and about 2/3 said no. I thought that this was a tricky one. So the answer is actually A, and it's because it's on the basis of because of sex, like these gender stereotypes. And then the Supreme Court, that was out of the Second Circuit, and then the Supreme Court affirmed that opinion as well. Okay, moving off of our hypotheticals here. So I want to have another poll here about what the court's decision addressed. Now, I know we haven't covered all of this, but it'll lead into our next section. So let's do a poll about what did the court's decision address. So is it A, was it termination for being gay and transgender, B, being gay and transgender, and segregated bathrooms, and C, adding on dress code as well? What did the court's decision address? A, B, or C on that? And let's actually see close the poll, see the results. Yeah, I know you had to guess on this. So 92% definitely, termination for being gay or transgender. And we also had an 8% here that said it covered all three, so including segregated bathrooms and dress code. The court actually did not address those things. So I'm going to go into like some of the areas that the court did not address that you should be aware of, especially if you have clients that have some of these issues that might be coming up. So looking into the future, Bostock's logic about what it means to discriminate because of sex may invoke litigation about related matters. So as Trump's administration is rolling back protections against LGBTQ, discriminatory protections in healthcare, we might see things like that. It might invoke litigation under the Fair Housing Act and under Title IX, with both also forbid discrimination because of sex. With respect to segregated bathrooms and dress code, Justice Gorsuch pointed out that the court's opinion in Bostock case should not be construed to require any particular outcome pertaining to issues such as dress codes, locker rooms, or restrooms. So specifically called that out. So those issues, according to the court, would need to be addressed in subsequent cases. With respect to healthcare, the court in Bostock did not address healthcare protections. The logic about what it means to discriminate because of sex may invoke, like I said, litigation around this, as some of the protections have been rolled back. And then regarding religious exemptions, the court is still considering whether to grant employers with religious objections to LGBTQ people an exemption from anti-discrimination laws. So in the Masterpiece Cake Shop versus Colorado Civil Rights Commission case, that's 2008, Justice Gorsuch suggested that religious conservatives should receive exemptions from laws prohibiting discrimination on the basis of sexual orientation or identity. So kind of like showed his hand there, at least for how he would vote, but it still needs to be played out. So those are the things to come. So a few takeaways to talk about between Mickell and I.
And also, I wanted to point out, it's important what Kat mentioned at the end of the last slide, because if you look at the way Justice Gorsuch voted and the tenor of his opinion in the 2008 decision, the wedding cake decision as some refer to it, that is really at odds with how scholars or practitioners or politicians would have thought he would have come out on the Bostock decision. So that really does kind of highlight and emphasize what a big deal it was for him to come out and adhere to his textualist interpretations. And many disagree whether or not applying a textualist interpretation, he arrived at the right decision. But 5 other justices on our highest court agreed with him that he did. So I think that is a really good foreshadowing that we are going to see more about this. And so turning then to takeaways for you today, whether or not you're a practitioner providing advice to clients, or you're an in-house counsel, or you're running your own business, or whatever it may be, there are some things that you can do based on this decision and to prepare for what may come. The first of which is to take a good hard look and examine your corporate culture. Do you have diversity, equity, and inclusion in your culture? Is it a part of your policies and procedures? Is it a part of the way you do business? Is it a part of the conversation in your workplace? And another thing you can do in that regard is to examine your existing handbooks. A lot of companies that have handbooks that drop in that boilerplate Title VII language that don't even incorporate a local state statute, but certainly haven't now incorporated the expansion of protected classes after the Bostock decision, will be outdated and stale. And then you're going to want to examine your workplace practices, because we all know that practically speaking, we can put the law down on paper in an employee handbook, and we can even provide training. But the way we conduct business day to day also sets a precedent. And so if you are an employer, or if you are a lawyer defending an employer or representing an employee, you're not just going to look at what was put down on paper. You're going to look at the way the parties govern themselves in the employment relationship and practice. So really looking at your employment practices and what's going on in the workplace would be a good idea. Again, are your written policies in line with the Bostock announcements? 32 states had done their own sort of expansion, but most of those would have been out of step with what the Bostock decision decided. So looking at those and at a minimum expanding the classes that are covered under Title VII. Are your employees' interactions in the workplace problematic? My guess is that as you take a good look at the practices and the interactions among your employees in the workplace, you are going to find that there are opportunities for growth. There are opportunities that you can use to educate your workforce about the conversations around DEI and how you can improve the workforce. There's lots of data also, which is kind of beyond the scope of what we're talking about today, but there is a plethora of data that supports when we have good DEI in the workplace, when we have an open door policy, when we have robust discussions where people, like Kat's background says, can bring their whole self to work, that actually improves productivity and can improve the financial bottom line of the company. If you don't, you're at risk of a Title VII complaint. I imagine in the wake of Bostock, we are going to not only see an increase in the number of charges that employees file, but an increase in the number of cases that the EEOC is investigating and taking up as well. Are there other ways you can improve the culture, send a DEI message, and be proactive to protect the company from Title VII violations? This doesn't just apply to the handbook. You need to look at your benefit plans. You need to look at your interview processes. You need to look at your exit interviews, your job descriptions, the way you advertise. This kind of human capital finds its way into all of the facets of our business. And last but not least is workplace training. How might that be updated and improved? And I know, Kat, you do a lot of training for Lucid, and I'd love to hear, and I'm sure we'd all love to hear what you think would be some improvements in training.
Well, I'll tell you, and this goes a little bit with the training, but I'll tell you in the wake of this decision. So I'm at a tech company. It's a SaaS software. We talk about diversity and inclusion all the time. Like it is a hot topic. And in the wake of this decision, we have a few transgender employees, and some are out and some are not, and like working with, you know, my department about when they want to come out at work and things like that. Anyway, in the wake of this decision, it was amazing because we have an internal instant message, Slack is what we use, and they came out and like were really excited and celebratory, and it was really amazing to see other employees like happy face emojis and like being supportive. And then, but then on the back end, I had quite a few employees come and say, but how, what do I say and what pronouns and can I ask them? And they wanted to be, like the employees wanted to be inclusive and say the right thing. And so we did quickly put out, and we actually asked our transgender employees and said, hey, what resources do you think is appropriate? And what can we send employees? And do you want us to do that? Do you want to do that? And so we had this partnership, and it was really great. And so we set out some resources and had not a town hall, but just kind of like a fireside chat around this. And it was a very positive experience. And partly, fortunately, the culture was already that way. But it was a really good opportunity to say, hey, this happened. Let's give you some more resources about how to talk about this and what's appropriate to say. So it was not the traditional training where we all sit around and we listen to the anti-harassment and anti-discrimination training. It was much more a natural opportunity to take advantage of that. So I'd encourage you to take advantage of it if you haven't already.
Now, I think we have a couple of questions. There is one in the Q&A box. I'm going to read it out loud, and then Kat, why don't you take the first go at answering?
And Mickell, before you do that, do you want to close the slideshow?
So you can just
Sure.
stop share. There you go.
Yeah, okay. If demonstrated by facts, can a case now be brought for discrimination based on height or weight?
Well, certainly you can bring a case for anything. I don't know if it's going to be successful. I think it's still, at this point, it'll be still a pretty far stretch. Gorsuch here, like, what is still very textualist, and I think you'd have to follow the arguments that were made and see if they fit within those. I think it would be a far stretch to be able to make that, at least under Title VII.
Yeah, and I would say, I would agree, under Title VII, you would not be able to use those facts alone to have a successful Title VII case. However, if those facts were a part of a larger set of facts where someone being gay or homosexual or a part of another protected class were implicated, remember the but-for test says that it doesn't matter if you want to try and excuse the discrimination to say we took many things into consideration, not just someone's sex. We also took into consideration other things that were not a part of a protected class that will not allow an employer to escape liability. So something to keep in mind. That's a really good question. Another question is, are different outcomes possible under federal and state statutes? For example, for employers too small to be covered by Title VII, but big enough to be covered by a state Fair Employment Practices Act? And that is also a really good question. I think that to the extent we have, Utah's not like this because we use the same measure of 15 employees to be covered by the act as Title VII does. But for example, I know some of the local Colorado ordinances, you have to have 1 employee to be covered, whereas it's 15 under Title VII. So you could have a situation like that. However, with the Bostock pronouncement now, Title VII sort of works as the floor, right? So a state can provide more protection, it can't provide less protection. So there could be a different result if a state statute or a local ordinance decided to expand protections beyond that which Title VII now provides. If it, however, contracts that, it would likely be an unconstitutional local or state law that wouldn't be applicable. So it's possible, but what that state would have to do would be to expand what is offered under Title VII, and I don't know what that would look like at this point. What do you think, Kat?
Yeah, I agree. And I was trying to think about the case where you have a state that under the state law does not say gender identity, sexual orientation, but now we have Title VII. But I think you're right that with the US Supreme Court saying the law of the land is this, even if the state hadn't updated their law, that I still think that Bostock would be the winning argument at the end of the day.
Yeah. Oh, I see one more. Here we go. If you had a client that would qualify for either state or federal protection, which forum would you pursue their claim? That is a really good question. So what you have to do in these kinds of cases is you cannot go straight to court. You have to start by filing a charge with the Equal Employment Opportunity Commission, the EEOC, which is the federal agency. Or you can file with the local agency. For us here in Utah, that would be the Utah Anti-Discrimination and Labor Division, the UALD. Typically, however, what an individual employee will do, or a former employee, is they will file with both. And you can file with the EEOC, and then under something called a FIPA, they will transfer that to the local state agency to be looked at. But you do want to be careful because there can be different filing deadlines, statutory deadlines that apply. 300 days if you're dealing with the EEOC. In Utah, it's 180 days. So you would want to look at that as a practitioner very carefully in the beginning to see if you have different deadlines. And you would want to look at, because for example, let's say a client didn't come to you until day 250. You may not be able to allege a state law claim. You may only be able to allege a federal Title VII claim, in which case you would only file with the EEOC. You would want to look at that based on the facts and make a decision. Kat, do you have any thoughts on that?
No, it's just also a lot of states have, their commission has like a concurrent agreement, essentially an agreement with the EEOC that they run, like you said, at the same time.
Yeah, yep. Okay, those are the questions that I see in the Q&A.
Let me ask a question. Given that Gorsuch was a textualist and wrote his opinion based upon the text, going back to the first question on height and weight, would we then have to assume that Congress would have to create more protected classes before it would fit in Justice Gorsuch's opinion?
I think that is likely. You know, I am hard pressed to imagine a set of facts where height by itself or weight by itself could be a construed outcropping of one of the protected classes. I don't know, you wouldn't be able to say that weight is only ever implicated if you are a male, or weight is only ever implicated if you are a female. So by itself, I think it would be very difficult under a textualist analysis. My guess is those facts would most often not come to you in a vacuum, and we have lots of other facts that might give us more of an indicia about whether or not a protected class is implicated.
So without expanding the definition of a protected class, we probably won't get there.
I don't
Not
know.
under Title VII.
Not under Title VII.
Like obesity may be under like an ADA, Americans with Disability claim, for instance, like some sort of like medical protection. So.
But the ADA doesn't adopt those same kinds of protected classes.
Yeah, different.
And so it's very
totally different type of law.
Yeah.
However, one of the things that, again, is we could take a whole hour discussing this, is what are the implications of this decision on other similar kinds of laws, for example, Title IX in the schools. And I think that's why Justice Gorsuch, one of the many reasons he went out of his way to say, here's what we're not deciding today. We're not deciding dress codes and locker rooms and healthcare, because those cases are predicated, although on similar kinds of discrimination laws, different statutes, Title IX or the Affordable Care Act, or other kinds of laws. So they really were thoughtful to reserve for another day what that might look like under another law. Yeah.
Great. Well, thank you both so much. I really appreciated your participation, and this was really enlightening. I don't practice in this area of law, so it's fascinating to learn new things for me. For all of you that participated, we will be sending you the slide deck as well as the link for the YouTube channel after the 1st of next week. And we're so grateful you were all able to participate and join us. And if you have any further questions, you can email me at lori.nelson@law.utah.edu, and I will get the questions to either Mickell and Kat and get them answered to you for you. Thank you so much, everyone. And with that, we will end the webinar.